So what we're going to start first is, are you married? If the answer is no, then you are going to be looking at, okay, let's go down this side of the chart. So no, you're not married. Do you have living descendants? Do you have kids? Do you have grandkids? Do you have great grandkids? That's what's meant by living descendants. So if the answer is yes, then 100% of your estate goes to your descendants. So let me take a moment here to share with you, what does that mean? Let's take a really simple example. Let's say you have 3 children. They're all living, they're all adults. Your estate will be divided. Remember, you don't have a will. Your estate will be divided equally among those 3 living children, which means each of them will get 1/3, 1/3, 1/3. So that might be exactly what you want. So the state of Washington is trying to accomplish what they think that most people would probably want. And in this case, that might be exactly what it is: 1/3, 1/3, 1/3. Let's say that one of your children is receiving government benefits that are what we call needs-based government benefits. So their inheritance of 1/3 of your estate will then stop them from receiving benefits until they spend down the money. So that is a really poor outcome. If you have any special needs child or a child that has problems with handling money, you're going to want to have a will that contains a trust within it to make sure your child can keep receiving those benefits or doesn't spend their money in a way that could be harmful to them. Let's say out of these 3 children that one of them is deceased, but they left 2 kids, your grandkids. So the laws of intestacy of the state of Washington for a single person then say that 1/3 will go to child number 1 who's surviving, 1/3 goes to child number 2 who's surviving, and the deceased child, child number 3, who has 2 kids, their 1/3 share is going to be divided equally among their 2 kids. Your 2 grandchildren take the place of the parent, your deceased child, and they will each get 1/6 and 1/6. So that's very commonly what we will see when people don't have a will. I would be remiss if I didn't mention that all we are talking about here is what passes through a probate estate. With a will, there is a probate. Without a will, there is a probate. The only way you avoid probate is if you set up your estate to avoid probate, which can be done in many different ways. But will or no will, unless your plan, you've set up a plan, which if Washington has a state plan for you, you haven't set up a plan, there will be a probate. And when it comes to who's the executor of your estate when you don't have a will, it's going to be whomever the court appoints. That may be one of your children, they're an interested party. It could be somebody else, maybe even a professional if the 3 kids don't agree and they fight or they're not qualified or multiple reasons. So typically without a will, the probate is going to end up being a bit more expensive than if you had a will or if you avoided probate altogether. So you have the expense and you have the potential for conflict when you don't have a will. As I mentioned just a moment ago, this 1/3, 1/3 division under my example for the single person that has 3 kids, that's only for the assets that would pass through the estate, through a probate. Well, what's missing? Well, maybe you have a 401k or an IRA or a 403b or any of the other alphabet soup for retirement. So what that means is likely when you got that account, you filled out what's called a beneficiary designation on that. And you may well have said 1/3, 1/3, 1/3. So that is actually a bit of an estate plan that you have because you actually gave direction to an asset. If you didn't give direction to the asset, then it pays to the estate. And then if it pays to the estate, it goes under the same set of rules that I've been talking about, which is equally to your children. So if you have a beneficiary designation on your retirement account, it pays to your children under tax laws. They have 10 years to take out the asset, their share. It's called RMDs. They have to pay taxes on it. If it goes through your estate, then it is a 5-year payout. So it's advantageous from a tax perspective to make sure you have a beneficiary designation on your retirement accounts. Let's say that because you didn't want to, see the attorney, didn't want to get an estate plan in place, you decided to put one of your kids on your investment account or your bank account. And oftentimes, whomever you're seeing at the bank, when you set up an account, they say, oh, well, you want to avoid probate, right? And it's like, yeah, I don't want to go to probate. And so they say, just make this child of yours a joint tenant and joint owner with right of survivorship. They won't say that because they're not thinking that, but they'll say, let's make it a joint tenant on your bank account. And that could be a small account, or it could be a really big account. It could be a big part of your estate. What happens? Well, the laws of intestacy are not applying to make it 1/3, 1/3, 1/3, because through the titling of that asset, putting your one child on that account, they, upon your death, are the sole owner of that account. Let's say it's a big account, it's $600,000, for example. They have $600,000. Now, you may have talked with your child and they said, of course I'll divide it, Mom. Of course I'll give 1/3 to Bobby and 1/3 to Susie, and I'll keep 1/3. Well, it's their money, technically, and they may or may not comply with that. I don't know, but I can tell you that this is definitely a great opportunity for the children to get in a fight and to sue each other, and lots of legal fees to figure out, does the one kid get to keep the 600,000, or do they need to divest themselves and keep only 200 and divide the rest? So maybe that's not going to be a fight. Maybe it is. Maybe they're just going to divide it because they know that's what you wanted. If so, then the IRS rules say that they need to file a gift tax return. Will they do it? Maybe, maybe not. But you've really complicated things by putting any child on as a joint owner on any account of any size. So when I say that, do you have one kid on an account that's worth 10,000 and they're going to use that to pay your burial and this and that? That's okay. That's not a problem. But I'm talking about an account that is much more sizable. It's very problematic. So keep in mind, even if you don't have an estate plan and Washington says where your assets go, you're a single person under the laws of intestacy, your actions may have unintentionally caused one of your children to receive more. And you may have created a great opportunity for litigation. So let's say that you know that you only want 2 of your 3 children to inherit, then you must do a will, or you can do a revocable living trust and put your bank account in. But what the point of it is you must do your own estate plan if you want the result to be anything other than equally to your living descendants. So that is the basics for a single person. Let's go back and take a look. Let's say that you don't have any living descendants. So the answer here is no, you don't have any living descendants. Then what happens? Are your parents living, either one or both? If the answer is yes, then your parents get your estate, that which passes through the probate estate. Let's say your parents aren't living. Does it go to the state? Not yet. So if your parents are not living, then what we say is, do your parents have any living descendants? So your siblings, for example. If the answer is yes, then 100% of the estate goes to your parents' descendants. Let's keep going. The answer is no, you don't have any siblings. Are your grandparents alive? Yes, then it goes to your grandparents. No. Okay, then are any of your grandparents' descendants living? What's that mean? It means your cousins. Okay, then it goes to your cousins. No. All right, let's keep going. Do you have any stepchildren from a deceased spouse? Yes. Then there's another question. So let's start with no first. No, you don't have any stepchildren from a deceased spouse. Then the state of Washington does get your money. Okay. But let's say that, yes, you have stepchildren from a deceased spouse. Did that late spouse leave their entire estate to you? If the answer is yes, then your estate goes to those stepchildren. If the answer is no, then your estate goes to the state of Washington. So you can see that the state of Washington will end up with your money, but only if there aren't any of these, what we call heirs at law, to inherit.